Good evening. This is John Milburn for Laws 13010, Evidence and Proof. We're into week 9, and tonight we're talking about exceptions to the hearsay rule. And I'm just going to mute that microphone. Thank you. If you have a question, please unmute your microphone or use the audio facility. And I'm just looking to mute your microphone there. Thanks, Kate. Would you mind doing that for me? Great, thank you. But again, feel free to unmute the microphone and ask a question. And Catherine's joined us. Thank you very much. So tonight we're talking about the hearsay rule again, and we're talking about the exceptions to the hearsay rule, which means common law, Queensland statute, and the Uniform Evidence Act as well. So the Commonwealth legislation in the Queensland context. So we're talking tonight more about the steps to determine the admissibility of hearsay evidence. So as a rule, not all hearsay evidence is inadmissible. As we know, there are many exceptions to the hearsay rule. So we need to determine whether the hearsay evidence is admissible by adopting a two-step process. The first is the evidence tendered as truth of the facts as asserted? What if the answer is yes? What if the evidence, the hearsay evidence is tendered as truth of the facts as asserted? What does that mean? Any takers? Mary Bloggs told me...
Inadmissible.
Inadmissible. That's a general rule. Thank you, Catherine. Yep. So that's the general rule. What if the answer is no? What if the witness says, Mary Bloggs told me that something happened? You're not trying to prove that she said that because what she said is true. You're asking her for some other reason. What if... Yes, Kate?
It would be admissible. Admissible,
yeah. It's admissible because it's outside the ambit of the hearsay exception, or prohibition rather. So just as a general rule, if you're leading evidence which is on the face of it hearsay, but you're not trying to prove that what was said is actually true, but you're just leading the evidence to say that it's been said, then that's okay. It's outside the ambit of the hearsay rule. So, but if the answer is yes, coming back to what Catherine said, then we need to consider whether there's an exception before it can go in. So if the answer is yes, it will be admissible if it's not excluded by general rules. So how do you, I guess what we're really looking at now is the context of making an objection. Sure, we're talking about hearsay objections, but let's just broaden it for a moment. And how do you make or respond to an objection? How do you do it in court? What's the actual procedure? Yes, Kate?
Well, if it's in court, the party objecting normally stands up and advises the court they object to the whatever it is, and then the magistrate or judge presiding will make a decision in relation to it.
Exactly. Yeah, it's as simple as that. Just stand up, even if you don't have time to stand up, just while you're seated. Objection, and then usually just a few words. Might be objection, hearsay, objection, opinion, objection, whatever. The other side can then immediately respond. And if the other side, or if your opponent or the court wants further elaboration, then you have that opportunity to do so. But it happens really quickly. Now, the fact that it happens really quickly means that you've got to be almost anticipating it and you're ready to go. Because once the moment's gone, it's gone. And what we don't want is a situation where in a trial, we look back and say, well, we probably could have won that if this evidence wasn't in. Oh, I should have stopped that evidence going in. But once it's in, it's in. So you're in a trial and you feel the need to object to something that your opponent's witness has said or is about to say. Well, at least that's what you anticipate, that's what they're going to say. So how and when do you stop that? How and when do you deal with that? So if your opponent objects to it, and likewise if your opponent objects to evidence that your witness has led or is about to lead, how do you respond if they raise an objection? Now, tonight, of course, we're talking about the hearsay rule, which means that hearsay is permissible if it's accepted. But in a trial situation, there are many other objections apart from hearsay. So if you object, you might be objecting to many things. You may object to what your opponent asks, or even the way your opponent asks a question. Or you might object to the content of the question that your opponent asks, or you may object to the content of the evidence given by the witness. So just briefly, some of these objections that you might want to raise, firstly relating to the way in which the questioning of your opponent, you might object to, well, what are some of the things that you might object to about your opponent's questioning?
Relevance.
I like relevance, that's good. Irrelevant question.
Excuse me, John, maybe asking for opinion evidence?
Yes, it's a question that calls for opinion evidence. Yep, you might object to that. Thank you. And I've got my list and I'm going to add that one because I didn't put it on there. Thank you. Any others? Might be useful to have. Yeah.
Asking for expert evidence from someone who's not an expert.
True. Yes. I like that as well. So setting up a situation where it's just going to fail. The wrong question's being asked. Okay, so some of the others that I put down were these. The frequency of questioning, unethical questioning, leading questions inappropriately. I've just jotted down opinion and expert questioning. Argumentative questions or speculative questions. You know, objection. Counsel is inviting the witness to speculate. Questions that assume facts in evidence. So when you were driving the red car, objection, driving the red car is not in evidence. Irrelevant questions, I think, was an early one. And oppressive questioning. You know, answer the question, you know, being too bullying. So there's a whole range of things that you might do if you're going to object to what your opponent is doing in terms of questioning. But on the other hand, it might be that your objection relates to something that the witness said or you think is about to say. So one of those is hearsay, isn't it? Objection, hearsay. What other objections would you potentially raise if you don't like what a witness for the opponent is about to say or has said? We've covered some of them already.
Can you just repeat that? The internet went through this slowly.
Oh, did it? Yeah, my internet
distorted the question a bit.
My internet is horrible at the moment. So we were talking about where you as counsel might leap to your feet and object to your opponent's line of questioning. When would you, as counsel, leap to your feet and object to the witness's evidence? I'll start you off. Objection, hearsay. What other ones?
If they're trying to offer an opinion.
Very good. Any others?
Something outside of their expertise?
Yes, yes. You're either an expert who's going beyond what they should have done, or they're not an expert and they're purporting to answer as an expert. We talked about opinion evidence, objection opinion. It might be highly prejudicial evidence. Well, what's an example of that? Yes, Tani?
Oh, I was going to say that.
What were you going to say?
I was precisely going to say that. Yeah, right. I was going to talk about the prejudicial opinion.
Well, excellent timing, because now we're looking for an example of what might be a prejudicial statement. Can you give me an example?
My example would be in our assignment. There was one in regards to the son who was playing with the defendant, one of the defendants, and yeah, there was prejudicial because he said he was a bad guy. Something
exactly.
Like that.
Yep. So that's both prejudicial and it's character evidence. What if you're what if the witness for the opponent gets in the witness box and says, "Yeah, I know him. He's my drug dealer." You know, that's prejudicial evidence. It's not relevant to this case, but it creates a huge prejudice. So prejudicial evidence. You might object because the witness is giving character evidence. It's not relevant. Objection, character evidence, not relevant. It might be that the witness is giving privileged information, confidential information that shouldn't be there. Well, at the mediation, this person said to me he was willing to do this and that. You know, that's privilege, it's confidential. You might object because the answer is non-responsive. It might just be kind of a nonsense answer. You know how sometimes people, sometimes older people will respond to a question without actually responding at all to what was being asked, but they wander off on some other tangent. So that's kind of a non-responsive answer. Or it might be that you object because the answer which was proffered is volunteered. I didn't ask you that, so it's kind of related to that non-responsive. Or it might be that you object, witness is speech making. Witness is going off, we stick to the issue. Or it may be that the witness is giving evidence which is based on some unsubstantiated premise. It might be that it's a speculative answer, or it might be irrelevant. So there's a whole range of different things where you may leap to your feet to object. But tonight, we're only talking about one of those. We're talking about hearsay evidence. So I object hearsay. So you're in a trial and your witness is about to lead hearsay evidence. You think, what do you do if your witness is about to go into hearsay? How do you deal with that situation? No thoughts? Basically stop them. There's nothing technical about it. You just say, no, I don't want you to tell me what someone else told you. I just want you to tell me things that are within your knowledge. So you can even say hearsay if you like, but generally you just say, no, don't tell me what somebody else told you. And there is an exception to that. If you're trying to have that person lead evidence about what somebody else said, not because you want to prove that what somebody else said is truthful, but because of some other reason, then that's okay. All right, so you just say, please stop. If you're on the other side and you're the opponent, you will leap to your feet and say objection hearsay. So in order to object to hearsay, it's really important, don't you think, that you know what hearsay is? So let's have a look at that again. In other words, you can't meaningfully object to the leading of hearsay evidence if you don't have a really good grasp as to what it means, what it is. So what is hearsay evidence? Well, Firstly, hearsay evidence can be oral, or it can be something in written form. In fact, it can be in any form. And it's evidence by a witness of what another person stated on a prior occasion, and that's generally inadmissible to prove the fact stated by the person on the prior occasion is true. I actually went one step further than that and said you can even lead hearsay evidence of what you said on a prior occasion. But generally speaking, what we're talking about is the evidence of a witness about what somebody else stated previously in an attempt to prove that what that person said previously is actually true. So we've got that. That's hearsay. So that's what hearsay evidence is. If you're dealing with an objection and someone says, your opponent says, objection, hearsay, what are some of the things that you can respond to that? Because it happens quickly. Objection, hearsay, yes. And then you have to, a one sentence response to counter that objection. We have to do more than, no, it isn't. So it's not a Monty Python skit. We have to provide some substance. So your witness leads evidence. Your opponent says objection, hearsay, and you think, no, it's not. You can say, Your Honour, it's not hearsay evidence. This is evidence from the witness's own five senses. That's a pretty standard sort of response. Or objection, hearsay. No, yes, Your Honour, I concede the evidence is hearsay evidence, but is not tendered as truth of the facts as asserted. Please elaborate. Well, the evidence goes to establish a state of mind of the maker. What's another response? Objection, hearsay. Yes, it is hearsay evidence, but it's not tendered as truth of the facts as asserted. Why do you say that? Or what are you trying to prove? I gave you one. I'll give you another one. The evidence goes to establish the state of mind of the recipient. So we talked about that last week. Just need to be ready to give it. Let's go through it. So there are two situations. Third situation, you hear the words objection, hearsay. You stand up and say, yes, Your Honour, this is hearsay evidence, but it is tendered as truth of the facts as asserted, but it falls within a statutory exception to the prohibition. That's a very long answer, but we're saying it's hearsay, but we're allowed to lead this hearsay evidence. There's a statutory exception. Fourth response, objection, hearsay. Your Honour, it is hearsay. It is tendered as truth of the facts as asserted, but it falls within a common law exception. That is a common law exception to the prohibition against leading hearsay evidence. There are four responses. The fifth response is concede the point, yes, don't lead the evidence, withdraw that statement. So you can see that you almost need a little cheat sheet, don't you, to have in front of you so that when you hear those words objection, hearsay, you're on your feet, your witness's evidence is under attack, the judge looks to you immediately and says, what do you say? Well, you can either say it's not hearsay, it's direct evidence, or it is hearsay, but for one of these reasons, it's okay. Or the third general thing is to say, look, it is hearsay, fair cop, I don't wish to lead that evidence, I withdraw that evidence. So you need to be ready with those things. So as you proceed tonight, and as you generally read about evidence law, picture yourself in that situation, because you don't have long to respond, so you need to know it quickly. Okay, so the main one that we're going to talk about tonight are the exceptions to the hearsay rule. So what we're saying, what the evidence is hearsay. It is tendered as truth of the facts as asserted, but it's permissible, it's accepted. There's a lot of exceptions. Common law exceptions. Can anyone think of a common law exception to the rule against leading hearsay evidence? No? Yes?
Statement under duty?
Yes, yes, statement under duty. Very good.
And a statement made
Sorry, Dani? Did you say dying?
no, under duty.
Duty, yes, exactly. All right, so a statement made pursuant to a duty, that can be an exception to the hearsay rule at common law. So also statement of deceased people. So statements are admissible if the person making the statement would have been a competent witness had they been alive at the time of the trial, but they've deceased. And they can be a declaration against interest, or a statement made pursuant to a duty, which is Dani said, or a dying declaration. So a statement against interest, a declaration against interest is this. So a declaration against interest is an assertion made by a person who's now passed on, which the person knew to be against their property or proprietary interest at the time it was made. Evidence from someone who heard that declaration is admissible as an exception to the hearsay rule because it's a declaration against interest of a deceased person. The other, Dani said, a statement from a person who's since died, which is made pursuant to a duty to report or record an action, is admissible as to the truth of the matters contained within that statement, that is, in relation to what the person was under a duty to report or to record. And dying declarations. So a statement made by a victim who is in a settled but hopeless expectation of death is evidence of the identity of the assailant or any other circumstance about the death. And when it comes to all of these things, we're looking at the civil standard, not the criminal standard. So essentially, statements by deceased people in certain circumstances can be the subject of hearsay evidence when given by a person who heard those statements in court as to the truth of what was being said. So at common law, some other exceptions to the hearsay rule include statements in public documents, statements concerning the maker's contemporaneous physical condition, and also some evidence which is given in court, previous. So let's think about that for a sec. So at common law, we have a situation where someone gives a statement about a prior proceeding, and that would be admissible at the trial. A good example of that is at a committal. So if someone makes a statement at a committal, then it's a statement which had been made previously, but it can be admitted into evidence, even though it was a previous statement, because it was made at the committal of the matter. Or it may have been a previous trial of the accused. You know, we often have mistrials. I think Kate would probably know all about mistrials getting in the way of court calendars. And they can be admissible in later proceedings. Or it might be a previous civil trial between the same parties, or it might be res gestae. So the point is there are a number of exceptions at common law which would allow as admissible evidence something that would, but for the exception, be inadmissible to prove the content of what was being said. So that's common law. Let's have a look at the Queensland statutory exceptions. Now the main thing is when you look at the Evidence Act for Queensland and you flick through the index, you'll see that there are, in reality, many exceptions in relation to the hearsay rule. But I think the most important provisions for you to consider are sections 92 and 93, because they specifically relate to the admissibility of documentary evidence as to the facts in issue in civil matters and criminal matters, which is 92 and 93. Okay, so documents are inherently hearsay. I think we all get that. But sometimes the content of the document is admissible as to the facts contained in the document in civil or criminal matters. So that's in sections 92 and 93. And be aware of the distinction between business records and other records of an undertaking or a business that are made in the course of that business. So if you look at section 92, when it comes to talking about the admissibility of documentary evidence, which is otherwise hearsay, it talks about allowing as admissible a statement contained in a document tending to establish the fact as admissible if the maker of the statement had personal knowledge of the matters contained within the statement and is called to give evidence, or the document is or forms part of a record relating to an undertaking made in the course of that undertaking by people who reasonably had knowledge or suspected had knowledge of that information, and the person who supplied the information is called as a witness. So there's a lot to be said. There's a lot of words in that, and it's a good idea to try and break it down. But you'll see that as far as civil matters are concerned, we talk about documents that are prepared as part of an undertaking in subsection B. And that's pretty broadly defined. In both instances of subsection 1A and subsection 1B, we presuppose that the maker of the document is called as to give evidence. But sometimes the person who made the document is not available. So what happens then? Subsection 2 of section 92 says that in a criminal trial, the condition that the maker of the statement be called as a witness need not be satisfied where the person who made the statement or supplied the information is dead, or by reason of bodily or mental condition cannot attend, or is out of the state, cannot with reasonable diligence be found or identified, or cannot be supposed to have any recollection of the matter. No one wants to cross-examine them, or it appears to the court that to call them would cause undue delay or expense. So that's the civil matters, section 92, really important. Section 93 also deals with the admissibility of documentary evidence as to the facts in issue, but it has different terminology and a different number of exceptions. So it talks not about documents prepared in the course of an undertaking, but it talks about documents prepared relating to a trade or business and made in the course of that trade or business. So it's much more narrow. So the circumstances where documentary evidence can be admitted as to the facts contained is much more limited in criminal trials because of the way in which the act is defined. And the circumstances where you can get that evidence into the trial in circumstances where the person who supplied the information is not available is more limited as well. So it's if they're dead, they're out of the state, cannot be found with reasonable diligence, or cannot be reasonably supposed to have any recollection of the matters. So there's 4 exceptions there where you can't find or you can't call the witness, as opposed to 6 in subsection 2, which deals with civil matters. So a few differences there, and just try to understand that difference between 92 and 93. Okay, so we've been talking about the statutory exceptions to the hearsay rule for documents in Queensland. Bear in mind, of course, that in cases where we're dealing with Commonwealth issues, the Uniform Evidence Act applies, which is the Commonwealth Act from 1995. And the important provision there is Section 59, which deals with the exclusion of hearsay evidence. And the way in which it's worded is this, that evidence of a previous representation made by a person is not admissible to prove the existence of a fact that it can reasonably suppose the person intended by that representation. That's the way they word, the Parliament worded the hearsay rule. And it talks about an asserted fact. So for the purposes of determining whether it can be reasonably supposed that the person intended to assert a particular fact by the representation, the court will look at the circumstances surrounding that. And subsection 1 doesn't apply to evidence contained in a certificate, and there are some specific exceptions to that. Now, those exceptions flow on from section 59. And again, as we showed you, I think last week, you've got that chart which talks about the exceptions to the hearsay rule. So those specific sections are in section 60, evidence for non-hearsay purposes. So again, it's the same rule. If you're leading the evidence which was otherwise on the face of it hearsay in the Commonwealth jurisdiction, but you're not doing it to prove the assertion, you're doing it for a non-hearsay purpose, then section 60 says that's fine, it's admissible. First-hand hearsay is available for evidentiary purposes in circumstances where it is, if the maker of is not available, section 63 for civil proceedings, or section 65 for criminal proceedings. So in some circumstances where the maker of the statement is not available, then the court will allow the introduction of the hearsay evidence. But a whole lot of other exceptions. Section 66A deals with issues to do with health. The hearsay, which says the hearsay rule does not apply to evidence of a previous representation made by a person if the representation was a contemporaneous representation about the person's health, feeling, sensation, intention, knowledge, or state of mind. So in those circumstances, the hearsay rule doesn't apply. Likewise, business records in section 69, tags and labels in 70, electronic communications in 71. That's a really wide one. That's a really wide exception because we're dealing with so many forms of electronic communication. So it says the hearsay rule does not apply to a representation contained in a document recording an electronic communication so far as the representation is a representation as to the identity of a person from whom or on whose behalf the communication was sent, or the date when the communication was sent, or the destination of the communication. So we're not talking about the content there, but we're talking about those peripheral issues. Also look at sections 72, dealing with Aboriginal Torres Strait Islanders, 73, dealing with marriage, family history or relationships, 74, dealing with public or general rights, 75, use of hearsay evidence in interlocutory proceedings. That's an important one because when it comes to dealing with an interlocutory proceeding, say an application for an injunction, then the hearsay rules won't apply in those circumstances. And evidence can be introduced that would not otherwise be admissible at the trial. Section 81 says there are exceptions to the hearsay rule which would allow the introduction into evidence of admissions. 87 talks about admitting hearsay evidence when they relate to representations about employment or authority. 92 talks about introducing hearsay evidence that relates to judgments or convictions. And 110 and 111 deal with the introduction of hearsay evidence about character or character of co-accused in certain circumstances. So there are other situations where that evidence might be introduced. Okay, now you've been really patient. I want to try and break that down a little bit so it's a little bit more real. So the way I've tried to structure tonight's discussion is this: that we have to know what the hearsay rule is, but we importantly have to know when to object, and we know how to respond to an objection. What that means is we need to have all this at our fingertips, figuratively speaking. So it's all very well to have all these list of things in the text, but it's another thing to apply it immediately in practice. So we need to make that transition so we can apply this immediately in practice. Let's have a look at the examples that are in the Evidence Act and see if we can deal with it in more detail. So the first example is this. We went through this last week, but I'll go through it again. So D is the defendant in a sexual assault trial. W made a statement to the police, and W said, X told me he saw D leave the nightclub with the victim shortly before the sexual assault is alleged to have occurred. Now that's clearly hearsay. So unless an exception to that hearsay rule applies, the evidence about what X told W cannot be given at trial. So we're right with that? That's fine. But what exception to the hearsay rule could possibly apply in those circumstances? This is the important part. Firstly, the first one you should always think about is...
Might be a res geste.
Yes, it could be a res geste. Yep, thank you, Catherine. Are there any other exceptions to the hearsay rule? An important one, I think, always think about this at the start, is are we actually leading this evidence to establish the truth of what was said, or are we leading the evidence for a non-hearsay purpose? Because if we're not leading this evidence, we're not tendering the evidence as truth of the facts asserted, then it may be that we say it's not hearsay, Your Honour, because the evidence goes to establish a state of mind of the maker, or the evidence goes to establish the state of mind of the recipient. I reckon that's the starting point. Think about that first up. But there might be other reasons why we're allowed to get this evidence into trial. X told me that that he saw D leave the nightclub shortly before the event. How do we get that into trial based on what we've just talked about, these exceptions? Can you see any other exceptions that might make it possible to get that evidence into trial? A tough one. And those watching the recording or listening have got a chance to come up with an answer as well. So we're saying clearly there's a hearsay statement. Your opponent leaps to his feet or her feet and says, objection, hearsay. You want this evidence to go in. You argue it can go in because it's an exception to the hearsay rule. And we're at the point where they say, the judge says, why? Why is this an exception? Have a look at your list of exceptions in the statute. Have a look at the Commonwealth Act, for example. It's a bit easier to follow than trying to work out the common law. Are there any exceptions in the Commonwealth legislation that you think might allow you to get that evidence into trial? Objection, hearsay. No, Your Honour. I submit that it's admissible because it's not tendered as to the truth of the matter. It goes to establish a state of mind. Fair enough. That's one. Number two, I'll get you started.
Excuse me, John. I will say the extent of proof is what the witness heard with their own senses.
Yes.
It's within his knowledge. No.
True, but of course, even though the witness heard X say this, the general rule is that W can't lead that evidence as proof that D did leave the nightclub with the victim. However, it may be that while the W is in the witness box giving this evidence about what X told, let's say, him, your basis for an exception to the hearsay rule might be that the maker of the representation, which was X, is unavailable. So you might say, well, Section 65 of the Act, it provides the appropriate exception to allow this hearsay evidence to be introduced. Also have a look at Section 66, or it may be that what we're really talking about here is an interlocutory proceeding, a bail application. So Section 75 would allow that to be admissible into evidence. Okay, let's take another example. It's, well, I'll leave you to have a look at the other examples in the Evidence Act, examples 2 and 3, and read them for what they are initially, and that is examples of hearsay evidence. But then ask yourself the further question, how would I try to get that material into evidence by relying on one of the exceptions, either at common law or statute, and see if you can come up with a list of maybe a few arguments that support that proposition. So what we're really talking about here is in Section 59 of the Commonwealth legislation, a statement of the common law principle against the admissibility of hearsay evidence, but the other provisions in Part 3.2 create exceptions to the rule, and I want you to be thinking about how you would actually use those objections if you're put on the spot in a trial having to argue that this material should be admitted. Okay, so have a look at first-hand hearsay in civil cases, which we talked about, 63, 64, 67, 68, and hearsay in criminal cases, 65, 66, and 67 of the Commonwealth, the Uniform Evidence Act. Okay, well, you've been really patient tonight. I'm just about ready to wrap it up. Do you have any questions about what we've talked about tonight, or the assessment regime, or generally? It's a no? All right. I'm going to ask a favour. You would have noticed the big red button on the top left-hand corner. I would ask that you please provide some feedback. If you've got 5 minutes, I'd really appreciate it. I'm not talking just to the people that are here tonight, but the class generally. It's really important for the university to get that feedback, and it's really important for me to get that feedback, so I'd really appreciate that. Okay, well, thank you for your patience. Thank you for listening. The lesson for tonight is think critically about what you read and pretend for a moment that you're in the witness box, you're on your feet, and you've got to justify your position in quick time before a judge. That means you've got to know the hearsay rule, and you've got to know the exceptions quickly enough to say objection, or here's how I deal with the objection. So we've got the idea? All right. Thank you very much for your patience. I'll end the recording now. We'll see you next week, and please continue to ask questions through you, crew. Really appreciate that. All the best. Bye.